Hello, buenos dias. Welcome, everybody. Excited to have so many of you here. We're going to just let people file into the room. Looking forward to this conversation with all of you today, though. As you're joining, if you want to put your name and your organization in the chat and what states you're working in, I think it might be a great way to connect attendees as well as panelists with each other. So feel free to pop that information in the chat. We'll wait just another minute or two for people to join us. Great. Wait one more minute. So folks to come in. Welcome anybody that wants to. Thanks, Alex. Anybody that wants to put their name in the chat, tell us where you're working. I think it's helpful for us to see kind of who across the country is working on these issues. You may want to connect with each other or with panelists. Panelists may want to connect with you. So just further building our community here and the network it's going to take to do all this work. This is great. So many great people here. Wow. Awesome. Okay, I think we'll go ahead and get started. I'm sure more people are going to file in here, but we've already got a really great group of people online. Thank you so much for joining us. We're really excited to be here with you today and continue building on the work this group has been doing and so many other people around the country are doing on trying to find new mechanisms for federal accountability in the face of what we're dealing with in this country right now. I'm Christine Soto de Berry. I'm the Executive Director of Prosecutors Alliance Action. And we work to advance justice, fight abuses of power, and protect local democracy and communities. So that has made us very busy in 2025 and 2026. We're seeing, obviously, in this moment, just unprecedented expansion from the federal government, a growing presence, and at the same time, a reduction in accountability. We've seen the hollowing out of the US Department of Justice, so many of the oversight and accountability mechanisms that we have relied on for decades, if not centuries in this country, are falling away. And that obviously is creating massive fear and distrust in our communities and a lot of questions about what we can and should be doing in this moment to stand up for ourselves and to stand up for our neighbors. The good news, and I think and why we're here today, is that there are opportunities for states to step in this moment, and they are doing that around the country. And we, and I'm sure many of you on this call, have been engaged in those efforts. And our hope is to keep building that connectivity and the momentum around these efforts. I think before 2025, and even as this last 2 years, we heard a lot about the supremacy clause and how the federal government has the authority to regulate itself and nobody else can step into that space. And what the actions of the last year and a half have shown us is that, in fact, there are strategic, targeted surgical ways that states can stand up for their residents and protect them against this overreach that we're experiencing. So today's briefing, we're going to focus on some of those strategies that this panel has been involved in and also leave some time for us to have discussion, hopefully at the end. So throughout, if you have questions, please put them in the chat or in the Q&A. We'll moderate those and make sure that we save time to answer those. And then hopefully we'll leave enough time that you can hear from the other panelists with questions that you might have. So today, we're going to really focus on state strategies around federal accountability. There obviously are so many things going on around on the preventative side and other parts of this work that are critically important. But the place where we bring work experience and expertise is around this accountability for federal actors. And so we're going to dive into that. We're going to talk about some coalitions across sectors. You'll see from us here today, we're an organization that works on criminal justice issues and democracy. We have Protect Democracy here, who's a democracy organization, and we have the Inland Coalition for Immigrant Justice, which is obviously an immigrant rights organization. And so we'll talk about those kinds of coalitions that are forming in the ways we can all be in community with one another. I would talk just briefly about the role of prosecutors. That's obviously where we come into this equation. You might be wondering, why is an organization of prosecutors working on these kinds of accountability measures? So, for a long time, we've known the importance of prosecutors around criminal justice, and we've seen many prosecutors around the country sort of flourishing in this work of reforming our criminal justice system. But I think what's come into sharp relief in the last year and a half is how important prosecutors are as a constitutional actor, as a backstop against abuses of power. And as we've seen the federal Department of Justice really be hollowed out at both the FBI and the US Attorney's Office, that burden is really falling to state and local prosecutors to step into the gap. We can have great laws on the books. We can pass these important measures and new legislation to try and create accountability, but we need enforcement mechanisms, and prosecutors are very important, one of those. So urging all of you in your communities to make sure that you're in dialogue and partnership with your local prosecutors, that they're engaged in this fight and that they're working alongside you. There are a lot of things they can do. They can create portals for evidence gathering. They can actually initiate investigations and prosecutions, as we've seen in Minnesota. And they can obviously protect victims and witnesses in their cases outside of this arena from further harm. So want to make sure that that's part of the conversation we have here today. But what we really want to turn our focus to now is around the legislative landscape. We're going to really dive into two efforts that this partnership has been working on, one being masking bills and the second being creation of a universal constitutional remedies. And I think we have a map maybe we could put up and just kind of show you where we're seeing these efforts around the country. So the first one is masking. You can look here and see if your state has an effort underway. Some have failed, unfortunately, but one has passed, the one we worked on in California, and many other are on their way. We know that Oregon, Washington, Virginia all have bills that are on the governor's desk, so hopefully imminently about to be signed. And it's certainly a place for all of us to make an additional push on those efforts. So we'll be diving into this bill. And then we're also going to be looking at universal constitutional remedies. Again, you can see across the country efforts being taken up. I bet many of you on this call working on those. A couple have failed, but two have already passed and more on the way. We've seen both Illinois and Colorado pass immigration-specific versions of this, and we're seeing California, Maryland, and Vermont have all passed their first house, so seem to be having pretty good progress there. So we expect to see passage of these bills in many of the states. So we're going to dive into this, and I want to invite our panelists to come forward. We're going to start with Hector Perea. He's the political manager at the Inland Coalition for Immigrant Justice. Hector.
Yeah, good morning, everyone. It's great to join all of you today. Like Christine said, my name is Hector Pereira. You see him pronouns. I'm the political manager for the Inland Coalition for Immigrant Justice. And just as some background for our organization, we are a regional immigrant rights organization in Southern California, servicing San Bernardino and Riverside County. We're a coalition of a little bit over 40 organizations in our region that convene to improve the lives of the immigrants. We engage in policy advocacy, immigrant legal services, direct community services, and community organizing and education. Sorry, just getting myself organized here. Okay. And like Christy mentioned, we here in the state of California have introduced and have already passed the masking bill, which and then was known as SB 627, the No Secret Police Act. This was passed in the last legislative cycle and signed by the governor in September of last year, went into effect. It was supposed to go into effect at the beginning of this year, but of course the federal government sued. And today I'm here to talk about why this kind of legislation is so necessary for the action and enforcement that we're seeing on the ground and how we can build really effective legislation to address it. And so just as some background, like I said, IC4IJ, we are a regional organization. We manage the rapid response hotline for the Inland Empire. And so through that hotline, we've been able to document a little bit over 1,500 confirmed immigration enforcement operations since the beginning of the Trump administration. And then over 90% of those operations were led by federal agents that were masked. And so we've seen this as a practice that is not just common, but is routine for federal agents when they're conducting immigration enforcement in our communities. And we've also seen that escalation of violence and brutality start in Southern California, right? So, for example, in our region, in the city of San Bernardino, this was in August of last year, federal agents shot 3 bullets at a family into their vehicle. When they pulled them over, it was pure racial discrimination. They had no warrant for them, they had no identification for them, they didn't even know their names. They just pulled them over while they were driving, and when the family refused to engage with them, um, they broke the windows of their vehicle, and out of reasonable fear, this family drove off. And when the family drove off, the agents shot at their vehicle 3 times, just point blank, with really no targeting, no regard for whether they may injure or kill someone that was in the vehicle, including the children. In Orange County, we saw a protester be permanently blinded by federal agents and their weaponry. And of course, we've seen so many examples in the city of Los Angeles and Los Angeles County in general, where we've seen this kind of escalation in violence and brutality. And of course, ultimately, that led to the kind of violence that we saw in Minneapolis and Minnesota. And I think I was looking through the chat, I saw a couple organizations that are joining us from Minneapolis, where we saw the murders of Renee Good and Alex Preddy, right? So this kind of continued escalation in violence, we know is facilitated by masking. Of course, it's directed by the administration that has given them the green light to behave this way, but offers need to feel comfortable behaving that way. And what gives them that comfort is masking and concealing their identities, being able to hide from or be recognized from their community members, and to be able to go with the knowledge that you won't be held accountable for the behavior that you're executing against civilians. And so the masking has led them to act with this kind of complete impunity. And that has been incredibly dangerous and threatening for our community members. And that alone is worth legislation to regulate masking, to prohibit the use of masking. But this kind of legislation also gets to overall accountability, right? You need to be able to know who that officer is if you're going to bring charges against them. And additionally, we've seen an overall growing distrust of all law enforcement. And now we've always known that distrust has existed even before this administration, right? But the actions of this administration have completely devastated any little distrust that existed there. Um, and they've begun to associate all of this activity coming from the federal government with all law enforcement. So, for example, I can say for our hotline, one of the most alarming trends that we were seeing is that folks were calling us to report crime. So we would have, for example, uh, mothers or wives who were victims of domestic violence call us first and ask if it's okay that they call the police, or if there's any way we can help them before them having to go to the police, because they were scared that calling the police may result in them being detained and deported. And of course, here in California, we have state sanctuary law that would protect against that. But that fear still exists because they see the behavior happening in their communities from these mass federal agents. And so these are the kind of alarming trends that make this kind of legislation so important. Um, and what kind of gave us the green light here in California is knowing that we weren't stepping on any toes here, and that we were completely within the state's rights to enforce this against the federal government. And so some of the key components of SB 627, the No Secret Police Act that we passed last year, include the recognition that masking is not essential to immigration enforcement. It was not a practice that they were doing before this administration. It is not even their uh, administrative policy, even now, even to this day. It is not their administrative policy. It is a discretionary practice. And we'll jump into this a little bit later when I go through the judge's ruling and why that ruling was still really promising to this kind of legislation. But one of the things that the judge points out is that if it was so essential to their job, it wouldn't be discretionary. They wouldn't leave it up to officers on whether they want a mask or not. They would just require them to do so. If it was so dangerous to them, if it so exposed them to doxing, if it's so necessary to their employment. And so we know that it is not their policy and it was not their practice in the past. It is not physically essential to their job in any way, any other way either. And so that kind of gives us the ground to then regulate this activity. And so the way that we structured it, we established a regime in which we had two penalties, a criminal penalty and a civil penalty. The criminal penalty was either an infraction or misdemeanor for a knowing and willful violation of SB 607 of California law. And the civil penalty, what we did was build on an already existing system of the Federal Torts Claim Act, where people can bring specific torts against federal officers for things including false imprisonment or abuse. And so those existing torts that there's already a pathway forward, we just added a baseline of recovery of $10,000, acknowledging that when people experience these kind of abuses at the hands of federal agents and that federal agent is masked, they experience an additional harm to them, an additional trauma to them. And so we've taken an already established system and established a baseline of recovery for that. And so those are the kind of that's the kind of regime that really pushed this legislation forward is take we're not reinventing the wheel here. We're taking systems that are already established that people already practice, and we're adding in the recognition that masking is an additional harm that that person experiences. And so that's the accountability, the regime that this legislation implements. Another important part of this legislation, and this will take us a little bit into the judge's ruling and the pause on the legislation right now, is the importance of treating all law enforcement, treating all governments equally. You need legislation that is evenly applicable, that applies to local governments, state governments, and federal governments. Some of you may know our law that passed in California, the No Secret Police Act, only applied to local and federal law enforcement. And the reason for this is just many of you all know that work in policy know that when you're trying to pass legislation, there are concessions that you have to make to get it over the finish line. We did not want to in any way hurt the actual teeth of the legislation. And so, in order to save that, we had to make concessions like removing state law enforcement from the structure of the law. Ultimately, that's what got us into a little bit of problems with the ruling and why the law is on pause right now. We are taking corrective steps to fix that. We've introduced and now been assigned to our first policy committee in the state legislature here in California, a bill to bring state law enforcement into that policy framework. And so we fully expect that to pass, to go into effect, and then we will be on much better standing to then enforce this law against the federal government in California. But that's why it's so important to treat everyone equally in your legislation, and not just treating all law enforcement or all governments equally, but treating all behavior equally, right? Our bill is not specific to immigration enforcement. It doesn't say that the prohibitions on masking can only not happen when there's an immigration raid or when someone is being stopped or detained for the purposes of immigration enforcement. Our bill applies to any kind of law enforcement behavior and practices. So that's also important too, right? Because a bill that would have only narrowed this to immigration enforcement, in effect, would have been a discrimination against the federal government because they're the ones that have that responsibility, right? And so it's important to treat everyone equally, both in terms of the agencies and the bodies that you're regulating, but also the practices that you're regulating. And that's something that 607 really got right, and what we got right in that California law, and what we implore all the other organizations, all the other states on this call to be really mindful of when they're crafting their legislation as well. That brings us now to some of the lessons that we learned from the advocacy and the coalition building around this campaign. Where ICIJ, we are a coalition, so we are always coalition minded. We work as a coalition. We partner with all the organizations in our region to advance the priorities to protect the immigrants in our region. And so we really had that mindset with advancing this kind of legislation. We had excellent co-partners with Prosecutors Alliance and another organization, MalDef, that is not on this call, and getting 6 to 7 over the finish line. And so working in coalition is always incredibly helpful. Partner with as many organizations as you can. And what we saw was actually really helpful for this is that this is an issue that touches everyone. And so it wasn't just immigrant rights organizations that were partnering with us to get this over the finish line. It was environmental justice organizations, criminal justice organizations that work to protect women's rights. For example, we had great advocacy from Planned Parenthood here in California, LGBTQ organizations. It's really a diverse coalition that we're able to build here in California, advance this because of the fact that it affects everyone. And that's really helpful because you get to benefit from the different connections that other organizations have to legislators. I can say, as surprising as it may sound, getting this over the finish line in our legislature was not an easy task, and getting those votes was not as easy as we thought it would be. We really had to fight for those votes. And for example, one of the losses that we had was that here in California, you're able to include an urgency clause in your legislation, and that just means that the legislation will go into effect as soon as it receives the governor's signature, as opposed to the beginning of the following year. But you need to pass a supermajority threshold, so two-thirds majority thresholds, as opposed to a simple majority, in order to keep that in. And so, because we couldn't get that supermajority, we had to remove that urgency legislation. And so that is why that partnership on the ground from community members that are experiencing this on firsthand. Many of your organizations maybe run rapid response hotlines for your region and are able to collect these kind of stories and connect to individuals to offer them services that are have these experiences. Telling their stories is super important. Bringing them over to your state capital to testify before policy committees is super important so that legislators can hear how deeply impactful this is to the communities on the ground, but also the partner organizations that are working through this every day. As much unity and collaboration as you can find throughout your state, that would really be helpful in getting you over the finish line. And just lastly, I alluded to this a little bit earlier, but we expected that the federal government was going to sue the state of California over SB 627. And we ultimately had a ruling. That is why the legislation is on pause right now. But the ruling was actually really promising for us because the judge's ruling didn't say that this law was outside of the scope of what California can enforce against the federal government. They actually said that it's completely within the scope, right? Their only problem was the exclusion of state law enforcement, which again, we are fixing right now. But I did want to share a couple of quotes that I thought were really promising from the judge's ruling. So, quote, the United States has not adequately explained how discretionary masking policies are essential to the operations or safety of federal law enforcement. If anything, the court finds that the presence of masked individuals, including law enforcement, is more likely to heighten the sense of insecurity for all. The court finds no cognizable justification for law enforcement officers to conceal their identities during the performance of routine, non-exempted law enforcement functions. And as to California's enforceability power, quote, the court finds that these acts serve the public interest by promoting transparency, which is essential for accountability and public trust. All right. To the one of the points the judge makes are non-exempt law enforcement functions. The bill that we crafted has certain exemptions that are necessary. So for example, respiratory gear for folks who are responding in California, we have a lot of wildfires, right? So we have law enforcement responding to incidents where there's a wildfire and the air quality isn't safe to breathe. So respiratory gear, helmets for the officers that drive in motorcycles that need to wear that helmet, medical masks, N95 masks. So those are the kind of exemptions that we had. We also have it for undercover operations like SWAT, which is necessary for their jobs. But anything outside of that, which is what immigration enforcement, the role that they play, is non-exempted. And the judge found that there was no reason for masking to be a requirement of those kinds of operations. And so that's what we mean that it was super promising and that the judge gave the green light to the policy. They said, California, you're completely within the power to enforce this against the federal government. It is a well structured law, well grounded as well, except for the inclusion of state law enforcement, which again, we are correcting, and we're hoping now with this correction likely will be sued by the federal government as well. But the judges in that case will see that the policy structure treats everyone equally, includes all levels of law enforcement, and in this case, now the law can go forward and be enforced in California. So I will pause there, but to talk a little bit more about something I mentioned earlier about the impact that this has on victims and why the legislation is so important, I did want to hand it over to Christine or to Robin to share a little bit more.
Thank you, Hector. So I'm Robin Sordelet. I'm the Survivor Center Director at Prosecutors Alliance Action, and really want to pick up that thread that Hector wove through for us about the impact of accountability and transparency on victims and survivors in our communities. Ultimately, Those are the qualities that make it possible for victims and survivors to trust the system enough to come forward at all. And these bills that we're talking about today protect that trust. I think it's really important to call out some of the hypocrisy in this administration's narrative about public safety, right? A lot of these actions that ICE is taking are being done apparently in the name of public safety and on behalf of victims of crime. But the fact is that masked, unidentified federal agents in our communities undermine both of those things. You really can't stand for victims while creating conditions where folks are afraid to call 911, are afraid to cooperate with investigations, or even show up to court. So, what they're doing here is not a public safety strategy, it's a public safety crisis. And these bills matter because the damage extends far beyond whatever ICE's targets are, right? Survivors of domestic violence, sexual assault, human trafficking, stop engaging with the systems that were created to help them. This is also affecting witnesses, right? We hear witnesses are disappearing. People stop answering the door for their victim advocates, and this is a chilling effect on communities. We have heard, anecdotally across the country, victim services providers and prosecutors who are already seeing it. Reporting is declining, cases are being dropped, and there are witnesses who just do not come to court. And if I can leave you all with anything today, I hope that you'll hear this, which is that legislation like this, unmasking legislation, is victim safety legislation.
Mhm.
I want to also kind of honor the organizations that are holding the line under really impossible conditions. State domestic violence and sexual assault coalitions like Valor in California and like the Colorado Coalition Against Sexual Assault in Colorado. Culturally specific orgs that serve immigrant survivors, tribal advocacy programs, even local rape crisis centers. These organizations are doing a lot of really invisible work to hold the line and protect folks. And they think that they deserve recognition, but also a seat at the table when these bills are shaped. Really to echo Hector's, the discussion about coalition building and being coalition minded. There are some really beautiful, unlikely allies in this space. And I encourage folks to look at victim services organizations as powerful coalition partners with credibility across political lines. When we approach legislators to talk about immigration issues, things can get really heated and really heavy really fast. But they will listen when folks who are serving victims and survivors talk about how it's affecting their clients. So framing this ask as protecting the systems that keep victims and survivors safe, that protect our communities, and not only as an immigration bill, I think that is a direction to go in that makes the language around this and the strategy around this legislation really powerful. I also want to encourage folks who are on the call, some of whom do work with and represent victims and survivors, but end this call and find one new connection. Reach out to coalitions that are serving victims and survivors in your states, in your communities, and talk about what is this impact that they're seeing on the clients that they serve. Send them bill language you're looking at. Ask them what they're seeing on the ground and invite them to be in this coalition. And even if they only serve in a kind of a background role and support the work that you're doing, that's really powerful. And if you're already connected to these organizations, which I hope you are, ask them to sign letters of support, to testify, to show up at hearings. All of this, these lessons we've learned from California are all rooted in building community, building coalitions about an issue that impacts our communities on so many different levels. So if anybody has any questions or wants more information about that, please feel free to reach out. I'm happy to answer questions. And in the meantime, I'm going to pass it to Travis Brunner, who is a policy strategist with Protect Democracy, to share more about this legislation. Thanks, Travis.
Thanks, Robin. Hey, I'm Travis Brunner. I'm a policy strategist, Protect Democracy, and our mission is to prevent our democracy from declining into a more authoritarian form of government. Pretty broad mission, but what we're talking about today is very relevant. Thanks, Christine, Hector, Robin. Your thoughts are so compelling and important today. I'm going to focus in on what we're calling Universal Constitutional Remedies Acts, or UCRA. In some states, they're called Congress 1983 bills or No Kings Acts also. And these state laws relate really directly to what Robin was just talking about regarding protecting victims of crime. They provide a way for individuals to have a remedy if a federal official violates their constitutional rights. And while bringing criminal charges against a federal official for violation of rights would require a prosecutor at the state or local level and political will to do that, the adoption of a UCRA bill gives individuals the power to file their own civil lawsuits and seek money damages, including punitive damages for those violations. And the cause of action doesn't require anybody else to act besides that individual. So when I describe the background of this work to people outside of this sphere, usually their reaction is kind of disbelief. They can't believe that a person can't sue a federal officer for violating their clearly established constitutional rights, but that is the sad state of things today. Hector alluded to this a little bit earlier, but I wanted to take a minute to think about the situations of Renee Good and Alex Preddy, whose killings I know weigh really heavily on all of us. They were both shot. We've all seen the videos. Their families want justice. Their families want answers. And if the officer who had pulled the trigger in those cases was a local or state police officer, the families could file a lawsuit, get into court, demand accountability from those very officers. And eventually a jury would be able to decide, would be able to make a decision. But Ms. Good and Mr. Preddy's families can't do that. Why? That's because the officers involved were federal officers, and no practical legal mechanism exists to sue those federal officers for personal liability. Another example, imagine that a local police officer breaks down your door without a warrant, terrifying and even injuring you or your family. Understandably, you would probably want to sue that police officer for violating your Fourth Amendment rights. And in 1871, Congress passed a federal law specifically to permit those lawsuits, 42 U.S.C. 1983, that allows civil suits against state and local officers for violating the United States Constitution. But if a federal officer does the exact same thing, you have no remedy at all. The solution to this absurdity is state-level legislation that holds federal agents accountable in the same way that state and local law enforcement officers are held accountable. The Constitution is the supreme law of the land. It applies to everyone. That includes federal officers, so they should not be able to escape liability. And the UCRA bills provide a solution to that. It says basically, if you violate the Constitution, you're liable. It doesn't matter if you work for local law enforcement or federal law enforcement, like the FBI or ICE. UCRA takes the exact laws that already let us hold police accountable and applies them equally to federal agents through a state law. Because whether their family should have a remedy for the loss of their loved ones should turn on whether their constitutional rights were violated, not what badge the officers were carrying when they pulled the trigger. Also, I think it's important to remember this isn't just about lawsuits and the right to sue in court after something like this. It's about impacting behavior. And right now, federal agents operate with this sense of invincibility. I mean, you've heard people high in the administration speak that kind of language, and they've been sort of promising to continue doing that. But if you pass a law like this in your state, it's going to change the calculus of those individual officers on the ground. No president can issue pardons for civil liability, for state law violations. And when individual officers' personal liability is on the table, they might think twice before they violate someone's rights. This concept is not radical. In fact, it's really traditional. For the first 200 years of our country's history, state courts were the primary place where we held federal officers accountable. We're just dusting off an old tool to fix a modern problem, and it provides constitutional protections for everyone across ideological lines. Most of the states where these bills are likely to succeed right now during active sessions are blue states, but we really think this could and should expand and get traction in more purple and red states soon. Because after all, I mean, the UCRA provides a remedy for all parts of the Constitution and not just against ICE for First or Fourth Amendment violations. It could be used to protect someone's Second Amendment violations against the ATF or something like that. At Protect Democracy, we initially started working on these bills last year in New York and California, in coalitions with some of the groups represented here today. And then after those terrible events in Minnesota, we started working with a lot of other states and a lot of other coalitions. And I noticed in the chat that some of the folks here are members of some of those organizations we've been working with. So if this type of bill sounds like something you're interested in pursuing or supporting in your state, I want to talk a little bit about some really important considerations about how to craft the most effective and legally defensible statute that could survive a court challenge. The basic idea is to craft a state statute that really nearly mirrors federal 42 USC 1983 and allows civil suits against state and local officers for violating the US Constitution. In our work sort of drafting model language for these types of bills, we consulted with an attorney who worked in the civil division of the Department of Justice on cases like these for 36 years. And we ran a lot of traps on bill language through that process and also through our work in a lot of states in recent months. We learned 3 important lessons through this journey. And forgive me if this gets a little in the weeds on constitutional issues. And just so you know, I'm an attorney, but my background is not constitutional law. So it took me a while to break these down and make them understandable. So I hope these are understandable. And if some of them are a little bit out there or feel a little obscure, just put questions in the chat and we can talk about it. So first lesson is this issue around the Westfall Act, or a pure cause of action rule. So the Westfall Act of 1988 broadly immunized federal employees from common law tort suits that previously were brought in state courts against federal officers. But it has an exception. It does not bar claims for cases brought for a violation of the Constitution of the United States. So this means when drafting UCRA bills, it's best if states limit the cause of action solely to one brought for federal constitutional violation. States should not create new substantive standards or add state-specific requirements or liabilities beyond the U.S. Constitution. The best approach, in our opinion, is to, 1, use the exact language of Section 1983, just changing the color of state law section to color of any law to ensure it reaches federal actors, and 2, limit the cause of action to violations of the federal Constitution by dropping the "and laws" part of Section 1983. This omission avoids impeding the state with controversy over what federal statutes it may cover and whether states can create causes of action for federal statutes where Congress maybe didn't provide a cause of action in the first place. The second lesson is around intergovernmental immunity, or the equal treatment rule. This relates to some of what Hector was talking about with SB 627 in California. So states cannot pass laws that discriminate against or directly regulate the federal government. This doctrine is rooted in the Supremacy Clause that establishes that the U.S. Constitution and federal laws made pursuant to it are the supreme law of the land. The Intergovernmental Immunity Doctrine prohibits states from passing laws that either directly regulate the federal government or discriminate against it without the consent of Congress. So we think the best strategy here is to make the bill universal and apply it to all employees, federal, state, and local, all government employees. Even though state and local officers are already covered by federal law under Section 1983, writing these new bills with that redundancy protects the bill from being viewed as anti-federal and struck down in court. And Hector talked about SB 627 and the ruling there, and because that original bill did not apply to state officers, a Clinton-appointed federal district court judge in California blocked the enforcement. As Hector mentioned, the ruling was really positive in other ways, and anti-masking laws like this are super important. And I think that this new version that Hector described is really likely to succeed based on that ruling and what within the language there and with input from law enforcement. So the third lesson is about qualified immunity. And this is a really tough one. At Protect Democracy, along with, I imagine, many of your organizations, we view qualified immunity for law enforcement officers as very problematic. We'd like to see a more reasonable and functional Congress address that issue and restrict or end qualified immunity defense for law enforcement. But in this moment where we have no way to sue federal agents who violate our constitutional rights, we've decided that it's more important to prioritize supporting bills that create a pathway for folks to seek a remedy where none exists right now. And that means crafting a bill that will withstand the scrutiny of the current U.S. Supreme Court, where these are very likely to end up. It's very unlikely that the court would allow a state law that subjects federal officers to stricter liability than state officers. And state officers have that qualified immunity defense in Section 1983 actions. A state law explicitly denying qualified immunity would likely result in the law being declared unconstitutional. Instead, we recommend a qualified immunity defense to ensure the bill survives those challenges, but to cabin it so that that defense only applies to this specific law, doesn't bleed into other areas of state law. Alternatively, silence on qualified immunity is a likely viable path because federal courts faced with statutory silence will almost certainly conclude either via statutory interpretation or through the creation of federal common law defense, that federal officers are entitled to at least the same qualified immunity defense that state and local officers have in Section 1983 actions now. Courts would then likely choose one of two paths. They could simply read the qualified immunity into the statute, or worse, a federal court sensitive to the appearance of supposed judicial policymaking may want to avoid the appearance of fashioning defenses itself and may hold the statute to be preempted. Lastly, while not one of the three main lessons I was describing there, I did want to mention retroactivity. Given that folks in many states have already had their constitutional rights violated by ICE agents, some states are drafting bills that would be effective beginning on dates before those incidents occurred. This, for example, the draft in Minnesota does that. And this is really a question of political will more than a legal question, but an important one worth considering if you're seeking to protect residents in your state in this way. All right, I'm done with the sort of legalese dive there, but I wanted to conclude with a few ideas about what you all as advocates can do if the UCRA sounds like something you'd like to see in your state. One, you could support a bill that's been introduced in your state if there is one. You could get your organization behind it, mobilize folks that can leverage lawmakers to pass it, and or encourage folks to amend bill language if it runs afoul of any of those legal issues that I described. While the list of states is constantly changing, you all saw that really helpful map the Prosecutors Alliance put together that describes the sort of state of play right now, but it is kind of changing week by week. And if you're interested in getting involved in an existing bill, don't hesitate to reach out to me. We're working with most of those states. Second, if a bill's not been introduced in your state yet, you can think about working with state legislature or partners in a coalition to introduce one. I'd also be happy to support you in that work if that would be helpful. Third, if one of these laws gets enacted in your state, I think organizations like many of the organizations that are here today will be really essential in educating citizens, educating attorneys about the existence of the law and the ability to use it to sue federal agents in your state, because without that, these laws won't have any impact. So thanks for taking the time to listen to these ideas. Hope you'll add your voice to the chorus of those working to pass these laws so that no governmental official is above the law. If you have questions or thoughts, love to hear them in the Q&A, and I'm going to throw a website in the chat that provides a lot of this information if you want to be able to look at it later and pass it on, and my email address if you'd like to reach out later to talk directly. I think I'll pass it back to Christine.
Okay, great. Thank you all so much. I know that was a lot of information, but we wanted to make sure you could hear all of that directly from people working on the bills, and we wanted to make sure then that we left some space for Q&A. We did drop a bunch of things in the chat as the conversations were going, so make sure you scroll back up. I'd say the first thing I would point you to is there's a petition that you're welcome to sign and circulate. It covers masking legislation in all the states that we're aware of. So if people sign that, it will go directly to the state legislature for their state to help encourage them to sign and pass the legislation. So that can be a helpful tool. Feel free to use it for yourselves. We're working on one now for universal constitutional remedies, and we'll share that with this group when we have that so that you can all circulate that as well. And we found that helpful in California to kind of push on legislators that were on the fence on the legislation. And then we also, I think, put in the chat the bill language from both of the California bills, the masking bill and the universal constitutional remedies. So there's links there. You can click on those now, as well as Protect Democracy's toolkit on universal constitutional remedies. And we're going to send out a bunch of materials afterwards, but just want to point you to those for right now so that you have those. And then I think we'll turn to some questions. We have one in here from Matthew Piers. Given qualified immunity is a matter of statutory immunity, why not expressly disclaim its applicability in the state law and instead incorporate state tort immunity law as applicable to law enforcement? And Travis? Can you see it there? Is it easier to read it than have me read it?
Yeah, let me go back up to sorry, I was reading one of the other questions.
That's okay. Yeah, I know there's a few in the chat. I'm going to try to pull those out now, but It is easier in the Q&A, as I told you, put them in wherever, and I should have said put it in the Q&A because it is a little hard to find them. So if you put one in the chat, if you don't mind putting it in the Q&A, it'll make that way I can make sure I get to it.
Oh, there's okay. Oh, there it is. Okay. Okay. Matt, I'm not sure I'm not sure that oh, QIs. I think the issue here is that if we that if you say, because we are really pointing to it's sort of like these bills are sort of like an analog to a federal law, right? So the Section 1983 is really a federal law, and this is an analog to that law. So if we attempt to restrict immunity through a state law, then once it gets to court, we're going to have a problem with the interpretation with how a court interprets that as applying to federal officers, where they're not going to feel like states have the power to reduce immunity of federal officers. Does that answer the question? I guess.
I'm gonna let Matthew, if you want to add something more on that, and then Travis can try to answer you. So I'll try to make sure I can get to as many questions as I can. So if you guys want to go back and forth in the Q&A or in the chat with any follow-up. The next question I wanted to ask is from Mark. I think Hector, maybe you or I. So he wants to know, is anyone working on changing state data protection laws to better protect victims and witnesses of federal misconduct crimes? Typically, that information can be shared with other law enforcement agencies, but we might need to protect the identity information from the feds without consent. We're looking at something in Minnesota, but may not be able to get to it in this session.
Yeah, absolutely. I mean, in California, we have sanctuary law, so there's already a lot of protections on data collection and sharing. But we still see this issue of the sharing of data between law enforcement agencies, typically between local law enforcement and federal law enforcement. And so I'm not sure if this is a phenomenon that happens in many other states, but here in California, we have what are called fusion data centers, which are essentially data centers that buy up all this data. And it's kind of like a meeting place for local law enforcement and feds to exchange information on people they're actively investigating, and things like that. And so there is a bill right now in the state legislature that is putting some parameters around how fusion data centers collect and share information. And we're also implementing mandatory inspections into these data centers. It would be unannounced inspections where state legislators would be able to go in and regulate and have to be an oversight in those data centers. So that's the most akin legislation that I'm thinking of is happening right now in California. I'm sure there are many other states that have these fusion data centers as well. And I'm happy to, if there's organizations here that are interested in that, I'm happy to connect you with the co-sponsors of that legislation.
Great. And then, Mark, there's also a lot of states are working on bills, obviously around sensitive sites, so not allowing people into courthouses, hospitals. I'm sure you all have seen all of those. Another thing that is being looked at is limiting court appearances for non-essential court appearances, so people are not subject to their location being known. And there are also bills around protecting people's immigration status in courthouses, in court proceedings, so requiring in-camera hearings before that kind of information can be discussed in open court to provide that protection. And then I would just say another place to think about, and this is where Robin and I, is thinking about U visa and T visa applications and making sure that people are really cognizant about what information is being shared with the federal government and applying for those because they don't stay in the local prosecutor's office. So just a few other places to think about. And we'll do some looking, Mark, see if anybody else, but I haven't seen anybody specifically working on data protection other than those kind of efforts. I think that's a great area to be looking at. All right, we have another question here. What are lessons learned from why masking bills failed in the Deep South? And also, why are the Carolinas completely avoided masking and criminal constitutional remedies bills, especially since North Carolina is a swing state with a booming Latinx and Latina and Asian communities? Yeah. Anyone, anyone have insights they want to share there? I mean, I think the thing we've seen sadly, even in blue states where or purple states, while these shouldn't be partisan, they have really broken on partisan lines. They did in California. We've been working with legislators around the country on masking bills, and we're hearing in places that you would expect it to pass, but where one house has got a Republican majority and a real dubious sense of whether they can get out of those committees or houses. So we're seeing a lot of that, unfortunately, break on party lines. So I don't know more than that, what the strategies have been. We've been trying to share the kind of the coalition we built around having immigrant rights and law enforcement voices and survivor voices as some ways to try and find a bridge or an entry point with more moderate or conservative legislators. Happy to connect with anybody if we can be helpful in that.
Yeah, I would just flag to maybe Travis, you can speak to this. I think those more conservative states may be arenas that are more friendly to the universal constitutional remedies legislation than the masking ones, because in theory, I mean, they could use that against a Democratic administration that is, violating their Second Amendment rights. So that is probably a more friendly arena for the UCR legislation than for the masking legislation. But Travis, I don't know if you want to speak a little bit about that.
Yeah, I think that's right. I mean, we haven't seen that yet with our
Mhm.
work on the UCRA exactly. I mean, Vermont is purple state that is moving one. That's like the example we have. But I am hopeful that, yeah, over time, UCRA bills might be seen as a tool, like there might be interest in UCRA bills in red or purple states thinking about other parts of the Constitution, like the Second Amendment. Um, I think, it's going to be a lot. It's going to be challenging sort of to navigate that politically because, of course, we want everyone to understand all of the applications, but hopefully we can get enough momentum in some of those states to move these forward to protect everybody.
Also say, those of you working on this probably may be having this experience, but in California, we did experience a lot of law enforcement opposition on the masking bill. So that may also be a reason bills are struggling. And if we can be helpful with the strategies we tried on that, we prevailed, but barely. Happy to share those kind of approaches we took we never were able to gain support, but we tried to neutralize what we thought were the most compelling arguments there and make sure we were accounting for legitimate law enforcement needs. There was a question around what is the state of what is status of efforts for criminal prosecution? So the only things that we are aware of at this point is the efforts in Minneapolis by both the local district attorney for Hennepin County, Mary Moriarty, and then the state attorney general there, Keith Ellison, have both been trying to gain access to the investigative materials for both murders of Renee Good and Alex Preddy. They've been stopped in that. We worked on sending a letter from 300 former federal prosecutors saying you should allow a concurrent state investigation into these crimes. That's standard practice. That has not moved yet. It is, of course, one of the demands that the Democrats have around the Department of Homeland Security funding. We have been training prosecutors on how to think about these cases. So if those, if you have somebody you want to connect us with, I think generally for local prosecutors, we don't really think our role is to prosecute federal agents. That's generally been left to the U.S. Department of Justice. And so it is a shift in understanding their authority there. There certainly are a lot of legal hurdles to bringing those cases that have to be contemplated upfront. But it is within their reach if a crime happens in their county or their jurisdiction to bring criminal charges if the evidence supports it. They just have to go through the battle of establishing that the acts were unreasonable and that there'll be a fight over whether it should stay in state or federal court. But that does not mean a prosecution can't happen from a state or local prosecutor's office. And we have been encouraging people to look at those cases. You heard Hector mention some of the things that we have seen and you all are seeing in your own communities. A very important place to start is with your local prosecutor and your local police to gather evidence. Portals are a really great way to do that. In Minneapolis, they created a portal, and in Illinois, they created a portal that allows citizens, residents, and community to upload videos or documentation they have of crimes that have happened. And then this allows the prosecutor to dive deeper into that and see if they can identify criminal activity that requires a prosecution. But if we can, reach out to us if you want tools on how to engage your prosecutor more, we're more than happy to engage with you on that.
Yeah, can I speak to a little bit more, Christine? I think
Yeah, please.
this also goes back to what we were saying about coalition work being so important. So the coalition work came with passing the legislation SB 627. But it also comes after the fact, right? So with the same coalition partners, we've been working at the local level to pass local resolutions that recognize the new state law and that also give some guidelines to those local police departments on how to document immigration enforcement operations in the city and when there's violations of state law. So for example, for those familiar with California, there's the city of Riverside. We worked on a resolution with them and the city gave explicit guidelines to their police department on SB 627 and our companion bill, SB 805, which was about requiring visible identification on violations of that law so that police officers can make reports, official police reports that then a DA could use to pursue the criminal charges against an officer or that a family could then use to support their civil lawsuit. So it's super important to have that coalition advocacy at the local level too, not just for the passing of legislation, but for the enforcement and all the follow-up that comes with making sure that it's made available to community members.
And then the last question I see here, success with city and county ordinances banning masking, etc. I know that LA County has an ordinance moving.
Yeah.
Chicago, I believe, also. Speak to those, Hector.
Yeah, I mean, I have to look into how LA counties is structured, but for the most part, I think it's mostly a recognition of the state law, and a support of that state law. And then, like I said earlier, putting some guidelines in for the local agencies to document abuses and have a pathway for their residents to bring criminal or civil lawsuits. So I think that's the most efficient role the local governments can play is making sure that their agencies know how the law works and that they're doing everything they can to have good documentation of violations so that folks could then use that to bring the civil and criminal charges. During the legislative process, that was also super helpful. I mean, here we had a bunch of cities and counties writing letters of support to the legislature in support of this law and imploring them to pass it.
Great. Somebody just put in the chat from Vera a resource they have for local governments, so you should certainly look at that. There's a lot local governments can do. Banning masking is a tougher one for them to do because of the enforcement. But there are so many ways local communities are standing up and being asked to stand up by advocates like yourselves. So I think looking at their toolkit and the opportunities there's lots around zoning. There's a lot to do around policing and cooperation or non-cooperation. And actually, as Hector was saying, gathering information so that prosecutions are possible. Those are all things that locals can and should be doing in this moment.
Absolutely. Yeah, and I actually wanted to uplift something that may be helpful for other states. One of the initial ideas that we had in SB 627, in the earlier drafts of the law, was prohibiting our local law enforcement from responding to and offering mutual support to any federal operations in which the agents were masked. That was something that we had in our first kind of drafts of the bill that eventually didn't make it in the final bill that was passed, but I think it's still something worth exploring for the other states. Part of the problem that we had was just the opposition from law enforcement on, the complexity of, responding to an operation when you don't know if they're masked, you don't know if they're even federal agents. So there was issues of like making it more difficult for local law enforcement. and having this blank space in which they don't know which operations they are allowed to respond to, which ones they aren't. But I still think for other states, it's an important pathway to explore to see what are the restrictions you can give your local law enforcement agencies on offering mutual aid when those agents are masked.
Yeah, I agree. So many good things here. I know we answered some of the questions in the chat. Some got answered in the course of the presentations, and I'm sure some didn't. So our hope is to stay in community with all of you. We know you all are here because you're probably already working on these issues. If there's ways that any of our organizations can support your efforts, I think you heard from everybody. We're all very eager to do that. If there's things you think we all can be doing, please let us know. We will follow up with as many materials as we can gather to share with everybody on the various topics. We'll share legislative efforts, we'll share toolkits, we'll share some that were posted by partner organizations in here. Just try to make sure you have as much at your fingertips as you can to be effective in your community. And of course, you can reach out to any of us. We'll put our emails and our organization websites in the chat so that you can reach any of us at any time. Thank you for everything you're already doing. We are deeply grateful to be in a fight with so many amazing people around the country and call on us when we can show up to help you. And together we can do it. So let's keep pushing. Take care, everybody.